Real evidence, real drama, real verdicts. Welcome to Judge Reports, where the courtroom secrets come to light.
On behalf of Cyrus Abadi, standing to me, right? Cyrus, please speak.
Good afternoon, Your Honor. Cyrus Abadi here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start, but I certainly have some questions.
I have a few things to put on the record, but I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Dawes, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation and our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Bauer at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 4482C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say, all the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. To say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination.
The very core item that's at issue is whether defense counsel before exam needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay. And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it because there's no legal basis.
Maybe that's the
What it
reason
requires.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and I stand by that.
Anything additional, Mr. Town?
At this point, Your Honor.
All right, this court is ready to rule so that there's an order that fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tanner, you will prepare the order. I will sign off, and that is the ruling of the court. Is there anything additional?